In a first of its kind order, the Michigan Supreme Court just issued a rule requiring judges in Michigan courts to refer to people by their preferred pronouns. Let's have a look at the rule and some of the opinions of the judges who either signed on or disagreed with this rule. On September 27, 2023, the Michigan Supreme Court enacted the following amendment of Rule 1.109 of the Michigan Court Rules. The amendment goes into effect on January 1st, 2024. It essentially pertains to the documents that are filed in court, as well as the way that judges have to conduct themselves in court. The amendment reads, "Parties and attorneys may also include Miss, Mr., or mix as a preferred form of address and one of the following personal pronouns in the name section of the caption: he, him, his, she, her, hers, or they, them, theirs. Courts must use the individual's name, the designated salutation or personal pronouns, or other respectful means that are not inconsistent with the individual's designated salutation or personal pronouns when addressing, referring to, or identifying the party or attorney, either orally or in writing." Again, this is a first of its kind rule. Michigan is at the forefront of this type of rule. And as you can imagine, there was quite a bit of comment before this rule went into effect. And there are judges who dissented from adopting this rule. So let's have a look at some of the finer points from the opinions of the judges, both who are in the majority and the dissenting opinions regarding adopting this rule. So Justice Welch wrote the opinion for the wrote the concurring opinion, which kind of outlines the majority's opinion with respect to why they adopted this rule in the first place. "Our courts and court staff must conduct business in a way that is cognizant of changes in language and societal norms. The amendments to the rule reflect that basic truth and acknowledge that with changes in our society, our vocabulary also evolves. In order to be fair and impartial, courts, as the face of the third branch of government, must conduct business in a way that does not give the appearance of misgendering individuals, intentionally or otherwise. A primary goal of this change is to ensure that the judiciary operates in a manner that is objectively respectful of the individual identity and personal pronouns of the members of the public that we serve, regardless of the subjective viewpoints of individuals working within the court system." It goes on. "The first objection is that the use of the pronoun they for a non-binary individual is grammatically confusing when referring to one person." The concurring opinion then refutes that basic proposition by saying, "You can tell the difference if I am addressing you, the reader, or you, the public. While it may take some additional time for someone to adjust to the change, society has navigated grammatical shifts many times through the centuries." The second objection raised to the use of a person's specified pronouns in the judiciary is that a record will be confusing if underlying evidence identifies a party by one gender, but that person prefers a different pronoun in court proceedings. The United States Supreme Court has embraced pronouns that match a transgender litigant's gender identity, using the pronouns she and her to refer to and match the gender identity of a transgender asylum-seeking individual. Finally, people object to honoring a person's specified pronouns on the basis that they do not personally agree with the notion that someone can switch genders or be non-binary. However, judges are ultimately public servants. We serve the entire public and are required to treat those who come before us with civility and respect. The gender identity of a member of the public is a part of their individual identity, regardless of whether others agree or approve. So that's essentially the main points from the concurring opinion. There's another concurring opinion written by Justice Bolden, and main point there reads, judges must set aside personal biases when overseeing judicial proceedings. There are 3 requirements within the canons that this amendment provides guidance and clarity about. They all boil down to how judges are expected to treat individuals in their courtrooms. First, judges should always be aware that the judicial system is for the benefit of the litigant and the public, not the judiciary. Second, without regard to a person's race, gender, or other protected personal characteristic, a judge should treat every person fairly, with courtesy and respect. And third, to the extent possible, a judge should require staff, court officials, and others who are subject to the judge's direction and control to provide such fair, courteous, and respectful treatment to persons who have contact with the court. In sum, the canons emphasize the expectation that judges will treat litigants with fair, courteous, and respectful treatment. This amendment merely falls in line with what judges are already required to do. But despite these concurring opinions, there were 2 dissenting opinions. One is written by Justice Zara. We're going to read a bit more of the dissenting opinion because there were 2 concurring opinions that kind of broke out their main arguments. So we're going to go into the arguments against this rule. I dissent from the implementation of this rule. As the United States Court of Appeals for the 6th Circuit noted, the use of gender-specific titles and pronouns has produced a passionate political and social debate. The hundreds of comments both supporting and opposing this proposed rule attest to this division. Some believe that the use of preferred pronouns is simply a matter of courtesy and that those who oppose it are stubborn, perhaps even bigoted. Others, however, believe they should not be compelled, especially under oath and or in conflict with their deeply held religious beliefs, to affirm a person's preferred pronouns that are inconsistent with the biological gender on that person's birth certificate. All told, this is a fluid political debate into which our judicial branch of state government should not wade, let alone dive headfirst and claim to have resolved. Such hubris has no place within the operation of a judicial branch of state government. So just to note, the dissenting opinion here points out that people shouldn't be required to, under oath, essentially, they shouldn't be compelled to use pronouns that they don't personally agree with respect to another person. So if you have a person who is biologically or on their birth certificate male who prefers to be called referred to as she, then a witness should not be compelled to refer to that person as she if they have some disagreement with that. But that's not what the rule does. The rule only applies to judges. That's it. The court is required to use the pronouns that the litigant wants to be used, or to refer to the individual as their name, by their name, or it gives them the means to come up with some other respectful way of addressing the individual. So this particular argument doesn't really fit with the scope of the rule. To the extent a litigant requests use of a pronoun inconsistent with the biological gender reflected on the litigant's birth certificate, courts should have the discretion to accommodate that request in deference to the litigant's wishes, or alternatively, refer to the litigant without using any pronouns. In this way, judges will not be required to act inconsistent with their religious beliefs, and every litigant will be treated with courtesy and respect. But again, the judges can always, according to the rule, use the litigant's name. They don't have to use pronouns at all. The only place that the judge has to accept the litigant's use of pronouns other than that which would otherwise exist if they followed what was on their birth certificate is when the litigant is filing papers, which might refer to them as Mix, as opposed to Mr. or Miss. There's another dissenting opinion A little further down, Justice Welch believes today's action is necessary to instill public confidence in the courts by reflecting societal shifts. Respectfully, I disagree on how courts acquire and maintain the public's trust. I certainly do not believe that it is by our ability to detect and measure public sentiment. For one thing, we do not have the training or institutional capacity to study and correctly interpret the necessary data. More importantly, although we are elected by the people, our duty in adjudicating disputes and overseeing the courts is not to provide the particular results that certain people or groups might desire on policy issues. Rather, we are elected to faithfully interpret and enforce the laws and regulations adopted by the policy-making branches so far as they are consistent with the Constitution. And with regard to our rulemaking authority, we are constitutionally confined to matters of practice and procedure, an area that does not encompass substantive law. In this realm, too, we should endeavor to remain neutral on pressing political topics and refrain from conveying any policy positions on them. So basically, this argument is that by adopting this rule, they are taking a stance on policy issues that the legislature is likely more attuned to and is more equipped to deal with. So those are the major opinions and dissenting opinions regarding the implementation of this rule. And it is a touchy political subject, a touchy subject with respect to our society in general. And on the one hand, you have respect for the litigants. And on the other hand, you have what seems to be judicial rulemaking that determines a policy position or adopts a specific policy position and gives the imprimatur of correctness with respect to a particular way of deciding that policy issue. So let me know what you think, whether this is a good rule, bad rule, and whether other courts should adopt it, because again, this is the first of its kind rule, and there are likely going to be other courts that either adopt a similar rule or have proposed rules that they refuse to adopt. What do you think? Should they adopt them or not? Let me know in the comments below. For now, my name is Nathan Saunders, and this is The Legal Good.